Thank you again for inviting me, and thank you everyone for joining today. As Judy mentioned, my name is Jason Buckingham. I'm a local estate planning lawyer. My office is in Benicia. I've been a lawyer for nearly 17 years, and I've lived in Solano County since 1986. So my entire adult life, I've lived here in Solano County. And what I do is I help families establish estate plans, and then when a loved one passes away and it's time to do all the heavy lifting and take care of the administrative work, I often will assist people who are serving in that role. So with a will, we call that person an executor. With a trust, we call them a successor trustee, but it's the same work: paying bills, dealing with tax and accounting things, dealing with legal issues that might come up, providing legal notices, and so on. And so that is rather, it's a time-consuming job. It takes a while, even though we don't have to go to court and we're not tied up in probate for what is right now the better part of 3 years. That's how long probate cases are taking in Solano County Court right now. We're still looking usually at a number of months, maybe to a year, and sometimes longer. Usually the timeline is dictated by whether or not we need to sell real estate. And we know in the current market, if you have a piece of real estate to sell, you just whisper it somewhere in public, and then 2 seconds later you're in contract. But we know not every market is like that. So in normal circumstances, the longest part of administering a person's estate is dealing with the sale of real estate, because on top of selling the real estate, there's a million things you have to do before you can even get it sold. Get it cleaned out, for example. Get it ready to be staged and listed for sale. If people are living there, they have to find other places to live and so forth. And yes. I'm sorry, Barbara, did you have a question? No? Okay. Okay. I saw the ring around the video change, so I thought maybe you did. So for pretty obvious reasons, it's important that whoever is left in charge of doing this very important job, that they have certain qualities. And that's really a lot of what I want to talk about today. I advise my clients. I happen to be the eldest of 3 children, and I'm also the lawyer in the family, so I get stuck with all the paperwork. But we all know those people who think, well, of course I'm going to leave my oldest child in charge first because they're the oldest. And while often that works out just fine, we know there are exceptions to the rule. And so what I advise clients is, you're thinking about certain personality traits. These are the kinds of traits that we want people to have in order to be well suited for this kind of work, because it is a particular skill set that we need to have. The first thing is we want somebody who's honest. I mean, that should go without saying, but I've been to court when things go wrong, and so I can tell you from experience, having someone who's honest will go a long way towards making sure that the job is done properly. Because being honest doesn't just mean, sir, you dropped your wallet, here you go. We're not just talking about that kind of honest. We're also talking about someone who can make an honest assessment of their own skills and their own limitations. And the reason that can be important is because the law requires that when a person is winding up the affairs of someone who's passed away, the law makes them be honest, because if they're not, there are financial consequences for them. They have to be diligent in doing their job. They have to be financially responsible. And they have to be willing to bring in outside help where it's appropriate. For example, hiring an accountant if they don't have a background in accounting, hiring a lawyer, hiring a real estate appraiser, because the estate tax rules and also the capital gains tax rules require that we have an appraisal in place. And if there's any chance a family member wants to keep a piece of real estate, then having an appraisal in hand will help protect against something that we've seen lately, county assessors being overzealous in deciding, oh, well, everything's $1 million now. So if you're going to hang on to this house, we're going to reappraise it and we're going to use an artificially high value. If you have an actual appraisal that was done by a licensed appraiser room by room through that piece of real estate, your appraisal is going to be more accurate. And even if the assessor doesn't like it, they know that a judge will side with you versus, their county employee who went online and looked at some recent closed sales and used the highest number, because unfortunately that happens sometimes. So we want somebody who understands the importance of taking care of those kinds of details and can do it in a proper manner. So honesty, obviously. We want someone that's financially diligent. We have to pay bills on time. We also don't want to panic and pay bills that don't need to be paid immediately, because there is an order that certain bills don't have to be paid immediately. And those are usually the people who complain the most after someone's passed away. And what I'm talking about right now are credit card bills. So when someone passes away and they have credit card bills, their credit card bills can be paid last because in the legal priority of creditors, an unsecured general creditor who issues credit cards, well, they knew they were taking on a certain kind of risk compared to somebody who's, say, a secured lender. If you have a home loan or a car loan that's secured by collateral that can be repossessed if it's not paid, we pay the secured debts before we worry about the credit cards, just by way of example. And then there are super priority creditors. The property taxes, obviously, they have to be paid because the county won't wait. So taxes of various sorts are always paid as a priority. But so are the expenses of a person's final illness and their funeral and memorial, and all the administrative costs. Sometimes I'll get a call, well, yeah, we just got the last credit card bill paid. Can you work for us for free until we get the house sold? And so that's just a small example. If the folks had called me a week or two earlier, I could have told them, look, you don't have to pay me an entire fee up front. I very often will break up my fees, and a lot of lawyers do this when we're doing administration. If we know a piece of real estate needs to be sold and there's not a lot of other cash, you want to have something, because even the lawyer has to take on some front end costs when we're representing an estate. But certainly, part of the executor or the trustee's job is they have to know certain things need to be done earlier in time than other things. And that includes, paying a creditor, and it's by the category of creditor that we're talking about. So, those are two really important qualities for pretty obvious reasons. We also want someone who is fair-minded. We don't want the kind of person, and we all know these people, who think, oh, well, I'm in charge. You just sit down over there, and if you give me any lip, well, then it says you're only going to get $1. I mean, if I had a nickel for every time I've heard somebody call to complain, well, my brother-in-law's in charge, and this is what he said. Yeah, I could have retired already. Unfortunately, sometimes people don't think about the idea that the person who's left in charge, they're really doing a bunch of make work. And in charge is kind of, it's not a really accurate description of their role. They are a servant. They are serving the interests of the law to make sure the creditors are looked after the way the law requires, but also their fiduciaries to all of the beneficiaries. And so sometimes, I'll represent a beneficiary where a trustee is clearly not doing their job. And I'll send a little letter to them and I'll say, if you don't have a lawyer already, please go hire a lawyer. It can't be me because I already represent one of the other beneficiaries. But the trust pays for the lawyer, or the probate estate pays for a lawyer when someone has a will or doesn't have any estate plan. And you need the advice because you don't realize you've already made some rather large mistakes in doing your job by thinking, you can strut around being the boss. That's not what your job is. Your job is actually to serve the interests of the beneficiaries, and whether you realize it or not, you have a target on your back when you're serving in that role, because a beneficiary, if they're upset, they can call an experienced, clever lawyer like me. And, I've had trustees removed in court before when they don't do their job properly. So making sure that we have someone who says, look, I'm going to do what's right. I'm working a job here for the benefit of someone who's not here to speak for themselves anymore. most of the time people take that role very, very seriously. But we all know that very often when you intermingle family histories and you have family members, I come from a large family. Each of my parents is one of 6 children. And the last time I counted, I have 30 first cousins who I've met. I lose count after that. But, you know, when you have that many human beings, we all know that within families, it's quite common that not everybody sees eye to eye on everything. And sometimes the person who's left in charge, if they weren't chosen properly, sometimes they will try to use this as an occasion to settle old scores or just to hold somebody over a barrel. But I'm here to tell you that often that's a fool's errand, because the person who's left in charge, they're just in charge of dealing with a bunch of tedious paperwork, but they don't really have, you know, they don't get to substitute their own judgment for the terms of the estate planning document. So keeping that in mind, making sure that we're choosing the person that we know will do the right thing, you know, that's as important as choosing someone who's honest and who pays the bills on time, because we don't want them deciding this is their big chance and now they're the big shot. Next thing that is important, I alluded to a moment ago, and that is somebody who knows their own limitations. All right, I'm an experienced lawyer. I've dealt with a lot of estate administrations. When we have accounting and tax related issues, I have several different experienced and very good CPAs who I refer clients out to. That's just not that's something I know I have no business trying to do. And that's important that we do the things that we know we're good at, and that we help people find other people who are good at the things that we're not good at. And that is an important quality for a trustee to have, because most of the time trustees are lay people. You know, they're family members or they're a trusted friend. And we know they have a heart of gold, and we know they're as honest as the day is long, and we know that they're going to treat all the kids fairly and equally. But they don't have the first idea about how to fill out like an estate tax return, or fill out a K-1 schedule for beneficiaries for assets that earn value during the administration of the estate. There are all these tedious things that are even beyond, you know, my experience and expertise. And I am all too happy to tell people, look, I'm so busy doing the things that I know how to do, I'm not going to try and take on something that I don't know how to do. And so whenever people are thinking about who they should leave in charge, that's another really big quality, is that you have to pick people. We don't want the person who says, oh, I don't need to waste money on a lawyer, I'll figure this out. Those people make mistakes. Then the people who are harmed by those mistakes end up finding lawyers like me, and we have to take that person to court. And sometimes in extreme cases where they lose money, they end up owing money to the beneficiaries. So trustees, if they make a mistake and it costs the beneficiaries money, they can be personally liable. And that all the more reason why, you know, if you know that and you're in charge, it doesn't make sense for you to forego hiring in expert help to help you with the things that you know are outside your areas of experience and expertise. So having somebody who is honest with themselves about the things they can do and the things that they can't is a really important step as well, because then we know if they're mindful of those things, we know they're also mindful of the idea that they want to do their job properly. And that's certainly part of it. The law actually requires, there's a section in the probate code that says when someone's managing somebody else's estate, they have to do the things they know how to do diligently, and anything they don't know how to do, not only are they empowered to delegate by hiring in a lawyer and an accountant and so on, they're required to make sure they do their job properly. So that's another big important trait that we want to make sure that we think about when we're choosing someone to be in charge of our affairs, if we're incapacitated or if we're not here anymore. And then there's one last quality that is good for people to keep in mind. We want people who can take a list of things that need to be done, and they can sort out, well, I've got to do these things before I have to worry about these other things, and then gets everything done. So they don't have to be an absolute taskmaster, but it doesn't hurt. We all know those people. And in fact, I've seen this, you know, in my own experience. Sometimes I'm hired in because, well, mom passed away 2.5 years ago, And I've just been so grief stricken, I don't even know where to start. And I'm overwhelmed. And I'm going to try and do everything in 1 week. And it's impossible. So, for my own clients, I actually provide a comprehensive set of instructions with an estate plan. It includes several different things that might come up during the client's lifetime, but then the last few pages are in case of incapacity and for when it's time to do the administration. So on one page, there's a list of tasks that we almost always need to do when we're administering estate. And then on the next page, there's a list of deadlines because certain things can wait. We don't have to do everything all at once. And very often, people will come and meet with me shortly after a loved one's passed away. And so they're grief stricken and they're overwhelmed. And so I show them that list and that timeline. And most of the time when people see that, it gives them that sense of relief. Okay, I know we're going to do this one thing right now. And then tomorrow we're going to be able to do this next thing and so on. As long as we have people who are able to follow things sequentially and make sure that each task gets done, that's another important quality, because when we're winding up an estate, we don't want to leave any loose ends because it can cause a lot of headache. I once got a call from a family where they'd done most of the estate administration, but there was a relative who was still living in the family home. And they wanted to wait to wind up the last bit until after that relative passed away, which, okay, that's fine, but you can actually do both. You can wind up the estate. We can still let Aunt Sally keep living in the house. And it had been a number of years, like 6 or 7 years. So we had to get them an accountant, and they had to do several years worth of taxes. Even though no taxes were due, they had to file the refunds because there was enough income where they owed a return, but the net income was below the taxable threshold. I think most years they had net losses because they had more expenses than income. But those are some examples of why we want people that know, okay, we're going to see this job through from the start to the finish to make sure we do everything correctly. And so the good news is that's not a very long list. I mean, I wrote down 5 different qualities that people would keep in mind. They are important though, and they're all kind of equally important if you just think about the nature of the job and also the nature of the various tasks, dealing with legal notices, dealing with impatient family members. Very often when I'm representing a trustee, I'll have a family member, well, when do I get my money? That's a very common thing. So maybe another kind of background quality is someone who has the kind of patience that they let those comments roll off their back, because it's nothing personal. Family members are always asking, well, isn't it done yet? It always takes longer than we hope. And very often they get less money than they thought they were going to get. Those are kind of 2 constants that we just see with estate administration. So
does the executor get paid? They
do. Yes. Anyone who serves in a role of executor, or when a person has a trust, if they're serving as a successor trustee, the law provides that they're going to be entitled to compensation. Now, for an executor, if you're an executor on a will, you're probably in court, especially if the person who set up the estate plan owned real estate when they passed away. If you're a homeowner, you're at risk for probate. That's a 3-year wait at the courthouse. And as a result, the probate code has statutory fees that are built into the probate system for executors under a probate estate. They range from 4 to 8% of the gross value of the entire estate. So it is rather expensive. I'll tell you, I've only done a couple of probates in my career. I learned early on the kind of practice that I do is just not well suited for doing probate cases. So I've only done, I think, 2 or 3 probates in my career, but I know enough about them that when you stretch out that 4 to 8% of the estate over a 2 to 3 year period, it's still blood money, because when you're in court, we have even more work to do because we have to do everything that the court system requires on top of everything else that I just described. So usually, when I'm talking to families, we're talking about a successor trustee who is administering a trust estate outside of the court system. And in that case, the law provides reasonable compensation as well. In most jurisdictions within California, including here in Solano County, that means 1% of the value of the trust estate for each year that it takes to do the administration. And most trusts are administered in a year or less. So usually we're looking at 1%. So it's also less expensive. And it's quite a bit less involved because we don't have to jump through the court system's hoops on top of everything else.
Mhm. Mhm. Okay. Mhm. Mhm.
So now that I've laid out, yes.
Just a question. If you are the successor trustee, do you have to take the fee that you're entitled to?
That's a very good question. The answer is no, you don't. And often,
Good.
yeah, very often the successor is also one of the beneficiaries. And if they take compensation as a trustee, it's income and they have to pay income tax on it.
Oh, okay.
So very often they'll say, I don't need to be paid. Each one of us will get a little bit more instead. And when they do that, they get that extra chunk. Everybody gets it usually tax-free because the estate tax is the exclusion is so generous. It's over $12 million now. So often, as long as the family didn't make the trustee miserable while they were doing the administration, that's kind of the litmus test. And I tell my own clients, if they're acting as the successor, look, if everything goes swimmingly well, you're probably going to want to waive the fee that you're entitled to. But if somebody makes your life miserable, you earned every penny of it. So take the pay the income tax, don't worry about it.
This was my sister. When she died, I was her trustee, but the trust was for her 2 young children who at the time were 12 and 7. And no, I didn't take any money because, I wouldn't get anything, but I thought it was more important for the kids to hang on to every cent that their mother was giving them when they turned a certain age. So, but
Yeah.
okay, so good. I didn't do wrong by not taking any money.
Right.
Not at all.
No,
Yeah.
okay, thank you.
Mhm. Mhm. Mhm.
So hopefully I haven't scared anybody off of the prospect of being a successor trustee. Just bear in mind that it is a very important job, and I think we all kind of understand that implicitly. But one other thing to bear in mind is that just because we've named somebody who we would trust to serve in that role, for a variety of reasons, they may decide that they're not in a place in their life at the particular moment to do the job, and that's okay. Often, when I meet with clients to set up an estate plan, I'll encourage them, pick a backup person, just in case the primary person who you've named is unwilling or unable to handle the rather detailed job that's involved when we have to wind up someone's affairs. In the trust that I provide to my clients, there's also a mechanism where if all the named people are unwilling or unable to serve, whether you named one person or a dozen people, if we run out of people who are named by name, then the people who are receiving the estate have the option of selecting somebody else to serve. And it can be someone they all trust, or it can even be someone who's licensed by the state. And so people who are clients of mine, I know you've heard about this already, but for other members who are in the meeting this afternoon, the state of California licenses people who have a background in accounting or law that want to do the work of administering and managing trust estates for other people. Those professionals are known as licensed professional fiduciaries. And I've had the pleasure of working with several local fiduciaries over the past several years. And I'm here to tell you that I strongly encourage anyone who thinks, well, I don't know if my kids, maybe they'll see eye to eye, maybe they won't. There are a variety of reasons why somebody might want to say, well, rather than burdening all the family with doing all this make work that none of them deals with, we can bring in somebody who's licensed by the state and who's experienced and deals with this sort of work every day. So I'll tell you, like I mentioned earlier, I'm the oldest of 3 children, and I'm the lawyer in the family. So naturally, I get stuck with all the legal paperwork. But like I mentioned, because of the level of work that's involved, sometimes a person in my position, you know, it would be so burdensome to try and do that work that it makes sense for them to bow out and say, well, you know, I appreciate that I was named, you know, that I was trusted to that extent, but because of what's going on in my life, I just really can't take on this kind of extra work right now and do a proper job. So often when families call me, you know, oh, my uncle passed away and he was the only one that was named, what do we do? And so I will tell families the same way that I tell my clients, you can, depending on how the estate plan document is written, either the beneficiaries or the court can appoint somebody that the beneficiaries have gotten together and chosen. And very often choosing a licensed professional fiduciary is a wonderful way to go about it. And so sometimes, like the estate plans I provided my clients, the trust will say, if all the named people are gone, then by the unanimous agreement of all the beneficiaries, they can just pick somebody. And sometimes we'll limit it. We'll say, like when we have young beneficiaries, well, if we know none of them is in a position where they can take up the mantle and do the work, then they have to pick a licensed professional fiduciary to fill that role. So great thing about fiduciaries is that because they're licensed, they tend to do a very, very good job, you know, every step of the way. That's certainly been my experience. I've worked, I want to say, with 3 or 4 different fiduciaries just in the past about 4 years or so. And I've been really impressed because, you know, they deal with this, they have processes and procedures in place, and they're very efficient at what they do. So that takes the burden off the family. It also helps in situations where, you know, we worry about one or more of the children. You know, we all know those families where they've got one good kid and then the rest of the kids are off doing their own thing. And that can mean all kinds of things. But the reward for the good kid is that they get to be run through a gauntlet while they're working for their other siblings. And sometimes, you know, that's not much of a reward at all. So it makes sense. Well, instead of having a target on the back of any of the kids, we can bring in a disinterested professional from outside who doesn't carry all the baggage of family history and, you know, that was supposed to be my Halloween costume or whatever the story is, you know, from years ago. I'll tell you, I had a family fight for 2 years over a spoon that went missing. A spoon. Not a spoon you could eat with, one of those dumb commemorative spoons that, you know, you put on the mantle. They knew that was my favorite spoon and we found the box, but the spoon wasn't inside. Like I'm sure you can imagine, I've seen a thing or two just in my line of work. When you have an outsider come in who's not burdened by who is supposed to get the spoon, you know, then they kind of shrug their shoulders and say, look, I've got a job to do here. And they're not burdened by all of that. So all of those manipulative techniques that family members get very good at inflicting upon each other, those don't work when you have an outsider like a professional fiduciary. So, you know, that's certainly something to keep in mind for anybody who's worried about, well, who should I pick? Or sometimes we'll have people and their families are spread out. They don't have anyone local. So that can be a challenge. And while it's not absolutely necessary that someone be local in order to do this kind of work, it doesn't hurt, especially if we've got real estate to sell. Being on the ground near the real estate for pretty obvious reasons, that can become an important skill, or just the act of being present can be important to make sure that that's done properly. But one of the bigger things, because, you know, when I mention to clients about licensed fiduciaries, well, a natural question is, how much do they cost? And the answer is that they're very, very reasonably priced. Most of them charge around 1% or less, in line with the local court rules. If they have to do some extraordinary things, sometimes they'll ask for more, but usually they have to file a petition in court for court approval, even to be paid more, even if we're not in court for anything else for an estate. Like when we're administering a trust, in most jurisdictions, including here in Solano County, for a professional trustee, if they want compensation that exceeds the court rule, they have to file a petition in court for approval. They have to show that what they did merits the extra money. And often what they do, I've seen fiduciaries discount their fees. I've seen fiduciaries who carry a business line of credit so that they can lend money to a cash-strapped estate so they can make sure things are done properly. And then what they do is they just reimburse themselves at cost. So they reimburse themselves for whatever money they laid out on behalf of the estate, plus whatever interest they incurred, off of their line of credit. So they have some experience, but they also have facilities available, like available liquidity, where they can do things that often we don't want family members to have to do. You could imagine if something happened and the rest of your family was relying on one family member to reach into their pocket to get their credit card, to cover basic things until we could deal with the bank that's frozen money, which unfortunately happens sometimes, or until we can sell a piece of real estate. So there are a lot of qualities that, all the qualities that I talked about earlier that we want an individual fiduciary to have, the licensed professional fiduciaries, it's kind of a job requirement. If they don't have those kinds of personality traits, then this line of work isn't suitable for them. So almost without fail, the ones who I've dealt with over the past several years, they've all exhibited those qualities. And they all work, they have lawyers who they work with on those rare occasions where we have to go to court for something. They have plenty of accountants, and they'll have bookkeeping staff to keep track of everything and so forth. So that's a good option for those people who want to get their affairs in order, but they're wringing their hands over the idea of, I don't know who I should choose to be in the role of doing this important work. Because I talk to a lot of people, and sometimes that is a real concern that people have. So I'm always happy to share the knowledge with people that, well, actually, there are people who are licensed, and some of them I know well enough where I provide contact information to prospective clients and say, here, if you don't have someone local, you go read up, here's the websites for these local fiduciaries, who I've spoken with or even worked with in the past. And some of them you can even name by name, so that on a financial power of attorney, for example, you can name them and they will serve in that role. Not every fiduciary will do that, but we're seeing a growing number who are willing to do that. And some of them will even act on an advanced healthcare directive. If you don't have anyone locally and you're worried, what if there's an emergency? There are some fiduciaries where you can name them by name, and they'll follow whatever instructions you put into your healthcare directive, and they'll talk to your doctor for you. So it can be an important resource. We all know people who maybe they're out here in California, but the rest of their family is somewhere else in the country, and those things can be concerns as well. So just know that having a professional fiduciary as a resource it's better to have the knowledge that options available, and then not need it than the converse. All right, and with that, since I've gone on quite a bit, I'm sure a few of you might have a few questions, so I'm certainly happy to open the floor to any questions that any of you might have. Mrs. Plant, I see you've got your hand up. You're going to have to unmute your microphone on your computer, and then we should be able to hear you.
Okay, thank you. Well, we are thinking about having our son do this, and he's very competent. He's a very successful businessman. We talked to him about it. He said, yes, he would take time off of his busy job in Colorado and fly out here. We've listed everything we've got, everything to do, who takes this, who takes that, blah, blah, blah. It should be very easy for him. But at the very end, you started me thinking about something we haven't considered, and that is, does he have to prove to anybody that he's done this well? And about the taxes, I guess he'll have to do our taxes. What's the end of his job, I guess is what I'm asking.
Sure. Yep. And so when we're closing out a person's affairs, The person in your son's role, for any other beneficiaries, they have to provide an accounting. And most of the time we do the accounting informally, so that we provide copies of bank statements, a closing statement if we've sold a house, and then copies of receipts for expenses. And then we put a little summary cover page on it. We say, well, here's the value of everything going in. Here are appraisal reports that show that. Here's everything we sold. Here's all the bills we had to pay. And here's what's left over. And here's how we're going to make the distributions per the estate plan document. Most of the time, like I mentioned, we don't have to do a full-blown formal accounting, but it's still a lot of information. And if we're worried that anybody might object, then often I'll advise clients, or if we have a situation like I'm helping administer an estate right now, where half of the estate is going to various charitable organizations. When we have charities, we always do the full proper accounting because they need it. If we can do an informal accounting, I usually recommend that because it's faster and less expensive. But if we can't, then we get the formal accounting with the help of a CPA. And not every CPA, is experienced in providing those. In California, our probate code requires a very specific format that is different from a general financial statement format. So we just need to make sure we're working with an experienced accountant. But part of that is we provide the accounting with the backup documentation to all of the people who are entitled to it, which is everyone who's going to receive a piece of the estate. And then often we'll include approval forms. We'll say, look, if everybody signs off and approves, we're done. We can cash out most of the estate. We hold back a reserve, and I'm going to explain that in just a moment. But most of the time, when it comes time to hand out checks, people are happy to approve. And on those rare occasions when they're not, if we've done a formal accounting, once in a great while, we take the formal accounting and we file it in court. We say, Judge, one of these beneficiaries is jumping up and down with their hair on fire, but we think we did things right. So please approve this accounting for us. And then there's a whole procedure in court that, we take care of that. So, but most of the time we don't go to court because people, approve the information they're provided. There's still a little bit of work even after that. That's the bulk of the work, is getting most of the money doled out among all the beneficiaries. Even after we do that, usually we still have a little bit of tax and accounting follow-up to do. So when we provide that accounting and the proposal that we're asking all the beneficiaries to approve, we also say, we're going to hold back a reserve of X number of dollars because we need to pay the accountant to do the final tax return to wind up the estate's affairs. And we might have an unanticipated expense or two. We always are very generous with holding back a reserve. We don't want an unexpected expense. The last thing the trustee wants to do, or the executor, is pass the hat around to the family after they've written a bunch of checks. So to prevent that risk, we hold much more than we anticipate we will need, to cover final bills. But then most of the time when people get the bulk of what their inheritance is, they're fine with the idea that, well, okay, yeah, we get it. We're going to have more than enough set aside. And then after everything's wrapped up, which usually just means filing the final tax return, and then paying, if there's any tax due, making sure you pay that tax bill. Whatever's left over in the reserve, and if we've done our job right, there should be money left over. Then we take that money and we divide it up and dole out the remaining money, and we send a receipt. And again, like a bank statement that says, well, here are the last bills that we had. We had to pay a tax bill and we paid the accountant to prepare the return. And here's a statement that shows how much money is left. And here's your chunk of it. And now I'm finally done. So that's how we wind up. And that's true even in probate. In probate, you get a final order and it closes out most of the court case, but then you still have to file a final thing. And it's usually months later after that last tax return is filed. So, the tax man's going to want to get their share. So like many things in life, we're always winding up with making sure that we tell the tax man whether or not we owe them anything, and then sending them a check if we do.
Does it ever happen, Jason, where there isn't enough money in the estate to cover the costs?
Sometimes that does happen. In that case, that's called an insolvent estate. And so what happens in a case like that is, when I see that with trusts, usually we've got real estate. And sometimes families will try to hold on to real estate even if it doesn't make financial sense. And so sometimes I have to have the very difficult conversation with a family and say, look, we've got all these bills. We don't have enough cash to pay them. So in order for you to keep the house, you're going to have to, find the money to buy out all the other beneficiaries' equity for whatever equity there is, but also to make sure that we retire all these expenses. And sometimes if there's not enough equity in the house, we haven't seen that lately. Even if you mortgage a house to the hilt, wait 6 months and then suddenly, we know this is not a normal market though. And so we can all remember, say 12 years ago, around 2010, I'd say a majority of real estate in California didn't have any equity just because of what had happened in the run up to 2008. So in cases like that, sometimes when there's an insolvent estate, luckily, it's very rare that family members can be financially responsible themselves, but sometimes, houses end up in foreclosure or things like that. But letting creditors know, for most creditors, if you tell them it's an insolvent estate, they just wash their hands of it because for some expenses, the creditor can only sue if they know there's enough money in the estate and they know the beneficiaries, the family members, are not turning it over. So like if there's a lot of equity in the house, but the estate is otherwise cash poor, sometimes you have to make that difficult decision, and we're selling the house because we got to pay these bills, and then whatever money's left over, we'll divide up among the beneficiaries. You can't keep the house after all unless you can find the money. If you can go arrange your own financing and pull that equity out so we take care of everybody, fine. So that does happen sometimes. In this current market, it's a little rarer. But the most important thing is in those markets where it's more common, like 2010, sure, estates were filing bankruptcy cases. So as a final measure to protect the rest of the family, the estate of a person who has passed away can actually declare bankruptcy when it's appropriate. All right, I saw Mr. Plant was waiting with bated breath, so please.
Oh, bated, maybe. Can you hear me okay?
Yes.
I just wondered if the decedent owes a great deal of money, can the creditors go after the children
Good question.
to get debt paid off?
Only in limited cases. It's limited to a case where the estate has enough money, but the kids abscond with the money and don't pay the creditors. Okay. That's if the estate itself is insolvent, then it's insolvent. And the prudent thing to do is that the estate declares bankruptcy, and then the creditors, we liquidate assets or, do whatever we need to do through the bankruptcy court. But there is a wrinkle. Even though kids can be liable, in the real world, it's very rare that they ever actually are. And here's why. Creditors have 1 year from the date that a person passes away to sue and to obtain the judgment against the beneficiaries. And they have to sue them all individually. So if you have several kids, they have to get judgments against all of them. And in the real world, getting a judgment like that in a year, because it's so unlikely, it's very, very uncommon for creditors to try to sue family members, even in those cases where there is equity, but for whatever reason, the family didn't pay the creditor off.
Interesting. Anyone else with questions?
Absolutely fascinating. I have a question about the bank accounts. My son is on my bank account, and when I die, can he go in and take that money out?
Yes, the answer is yes. As a joint account holder, when you add a third party to your bank account, as long as they survive you, then the bank has to hand the money over. Now, having said that, I will tell you that it's probably just as well, and maybe, for a couple of other reasons, I'm of the opinion that the better option is to name that child as a pay on death recipient for the account rather than having them as a co-owner on the account. I won't bore you with all the reasons, all the things that can go wrong. But one common one is when somebody's name is on a bank account and then the person who really put all the money in the account passes away, sometimes the surviving account holder will pretend as if that money was supposed to go only to them and wasn't supposed to be used for paying for expenses and debts and then divided up among other family members and so on. So once in a while, it can become a point of conflict among the family. Luckily, in the law, we have a concept known as a joint account of convenience, where we look past just the names that are on the account. So Margaret, for you, if you put all the money into the account and your son never made any contributions to the account and he only wrote checks off of it if you were ill or after you passed away, the law would say, well, he doesn't really own that money. We know why you added him to the account. And it was, for convenience in case anything happened and he needed to be able to handle your affairs for you. The thing is that I'm sure before just now, none of you probably heard of a joint account of convenience. And so very often when someone passes away, if the joint holder wants to take the money and walk off with it, the family's none the wiser. They just kind of shrug and say, well, they were on the account. I guess they own the money because, that's the first presumption. And then sometimes I have to give people bad news that, well, no, actually, they spent it already, but if you had known at the time, that money didn't actually belong to them based on the circumstances.
So how do we?
Go ahead, Margaret. Are you done? Go ahead.
Yeah, I am.
I there's only 3 of us: myself, my husband, and my daughter. And my husband and I are a joint on each other's accounts. But would it be advantageous to put my daughter on the account too as a joint?
I usually recommend if the idea is that
I'm thinking if we both died together, my husband would say an accident or something.
Mhm. No, and that's something I tell people that using the pay on death designation, as long as we don't run out of recipients, but pay on death, if the aim is that you want your daughter to receive the money in the account after you're gone, then naming her as the pay on death recipient is, the easiest way to make that happen. And then if you have an estate plan like a trust, I'm always telling my clients, after your child, you can name the trust, because what if the child was in the car with you, you're all going somewhere together, then the bank still knows who they're supposed to give the money to. And the reason that's important, if you've ever dealt with a bank when somebody's incapacitated or right after they passed away, they love holding on to the money and not handing it over the way. And so by just with this simple step of, we know we're not going to run, the trust can't pass away. So we know we're not going to run out of pay on death recipients. Then one way or the other, we're going to make sure that that money gets handed over when it needs to be. And then just in case you were concerned, well, what if I was ill in the hospital and my husband was also, how do we make sure that our daughter can pay our bills for us? That's why, if you have an estate plan, it should include a durable power of attorney for financial affairs. Then your daughter would get a doctor's note that would prove that you were too ill to manage your own affairs, and the bank has to let her pay your bills for you and so forth.
And what's the other thing that you said just before? She should be on the account as...
Oh, as a POD is what often banks will call it, pay on death. And it means what it sounds like, that the money's yours while you're alive, but after you're gone, they're just going to hand the money right over to whoever you've named, provided they survive you. And the nice thing with pay on death designations, they pass outside of probate.
Aha.
So
Well, how do you set it up?
you contact your bank and you say, I want to update my pay on death designation. So, and name whoever you want in whatever order you want. But if you happen to have a trust, it's a good idea to, if you've named people first, to name the trust after them as what's known as a contingent beneficiary, just in case. And then for at least one of your accounts, I often advise clients, for one of your accounts so that we have some working capital to take care of the preliminary expenses that come up when we administer an estate, it's a good idea to name your trust as the only pay on death beneficiary, maybe for a regular bank account that you keep some money in. That way, if you pass away, whoever you've left in charge will have access to immediate liquidity. Once we have a death certificate and once the estate has a tax ID number, then a lawyer like me can prepare a certification document, and then we serve that, we bring it to the bank and say, you got to close this account now because this person has passed away. Their account said that you pay on death to their trust. I'm the person winding up their trust. Give me a check. And then the trustee takes that money and opens a new account with it.
Yeah.
Okay. Interesting. Okay.
Mhm.
Yeah. So glad you asked that, Margaret.
Oh, thank you.
Yeah. So naming the trust as the contingent beneficiary. Okay.
Yeah. Looks like Joe has a question.
Yeah, just because I want to be clear on that. So if you have the pay on death at the bank, already Carlos already on my checking account, I would also want to put the trust on the account.
As a pay on death after. Yeah. So you got one person named first, then you can name the trust after them, because what if they don't survive you? Who does the bank give the money to at that point? And if you say, well, if you can't go give it to this person who I've named, then you're going to give it to my trust instead. And my trust already has all these backup provisions built in. So that's why you would name, your estate plan as the backup.
Okay, thank you.
Sure.
Mhm.
One thing I should mention, because some banks who shall go unnamed are known for making it difficult for people to name their trust as a pay on death recipient. If you go to do this with your own account and you happen to bank at one of those banks, when they ask for the tax ID number of the trust, tell them, I'm still here. My trust doesn't get its own tax ID number till I'm not anymore. And you already have my social security number. That is a common thing that trips people up. I get calls from clients. Hey, Jason, I talked to my bank yesterday and they said I have to get a tax ID number for the trust. No, the bank's confused. Part of the administration process, when a trust becomes irrevocable after someone passes away, then you do have to get a tax ID number. It's one of the requirements. But while a person's alive, for tax purposes, the trust is a disregarded entity because the person can revoke the entire trust whenever they want. So why would we get a tax ID number? And we know to open a bank account, you have to give the bank your social security number for, tax and money laundering reasons. So they already have that. And so that's a common question. And unfortunately, I've had rather pointed discussions with local bank managers sometimes about this very issue. Why are you even asking this? I talked to you 2 months ago and you asked my other client this very same dumb question. Haven't you guys figured it out yet? So it's just one of these minor frustrations that you run into, but I'll get off my soapbox now and just suffice it to say that the information they need about a person's trust for you to name your trust as the pay on death recipient, it's all contained in your declaration of trust document. They need the name, they need to know who the current trustees are, which is you, and then if you're married, your spouse, and then usually they ask what date you signed the trust. And well, you go look at the signature page and it's, I have never seen a trust where it didn't have a line for you to put a date on it before you signed it.
Okay.
Wow. Gosh. How come most of us don't know about this?
Mm-mm.
That's true.
I didn't.
Yeah. Was there anyone who knew about this? Raise your hand.
Mm-mm.
No. Uh-huh. Well, gosh. Huh. Okay. Anyone else? My goodness.
Yeah.
Now we're all brilliantly informed.
I saw Lois' hand.
Yeah. I don't know how to make this into a question. As for designating a trustee or a power of attorney, the qualities you mentioned, it makes sense for me to designate my husband, who is out of the country a large part of the year. And so in order to reach him, to bring him home at my death, someone would need to contact the Red Cross, and it would be somewhere between 24 to 48 hours by the time he would be home to take
Right.
care of things.
So, yeah, and I'll tell you, for my married clients, if you're married or in a registered domestic partnership, unless we have a spouse that has a serious health condition, spouse is always the first choice. But that's also one of the reasons why I encourage clients. After your spouse, who's the next person that you would trust to handle this kind of work? And so that's why we name backup people, because if your spouse is indisposed and halfway around the world, and say you have a medical emergency, hopefully in your documents you've already got at least one backup person named. That way, if your spouse is unavailable, it's as quick as getting a document from him that says, hey, I'm out of the country right now, so I can't serve. And then the next available person can.
I see. Okay.
Yeah.
Thanks.
Okay. Anyone else? Your last chance to add to your knowledge base. I'm curious.
I'm
was there
sorry.
someone else?
Yeah,
Oh, go on.
Joe. I'm glad you talked about the fiduciary, because I had talked with that. I know people who do that, and are they bonded? How do you? They're licensed, but how do you?
Right.
How do you protect? What backs them up?
Right. They have to carry certain types of insurance, and I believe a fidelity bond is one of them. So that if they make a mistake, or if through an act of dishonesty, client suffers a loss, and then we've got coverage there. But most of them will also carry errors and omissions insurance as well. And obviously, they lose their license if they make the kind of mistake that the bureau that licenses them disqualifies them from further serving as a fiduciary.
Mm-hmm.
So.
Well, I think that may be something I'd be interested in, because I have 2 children, but I don't really want to burden them with it. And we have a friend of ours named as an executor, but she's our age, and I just heard she has heart problems. So, thank you.
Absolutely. Yeah. And if you go online, the bureau that licenses fiduciaries, you can search by county or city. You can find local fiduciaries through the licensing website. And I know the website ends in .ca.gov. It's a state agency site. But if you just search California Professional Fiduciary Licensing, they should be one of the top results. So that if you want to do some research for local fiduciaries, that would be a great place to start.
Is it important that your executor be in your state?
Actually, it's not. And we've learned this. This is one of the very few benefits that we've kind of taken away from the last couple of years, living locked down, is that with the advent of technology, it's very, much less burdensome than it used to be to wind up someone's affairs from afar. And I'll give you an example. I'm helping administer 2 trust estates right now, where one, the successor lives in Nevada. So that's not that bad. That's an hour flight from Las Vegas to here. But then the other lives all the way on the East Coast, across the country. So, and as we have things come up, we get on the phone, we exchange emails. We've been able to do everything that we need to do. So it's not absolutely vital. On a power of attorney, local is often better. But even that, it's not absolutely essential, because again, as big as our country is, we're no more than 3 hours ahead or behind anybody as far as time zones.
Right.
So we can get a whole lot done. Now, to Loa's point though, if you've got somebody who, is on another continent out of the country, then again, by naming backup people on your various documents, if the initial named person is so far that we know it's going to be a logistical nightmare, than getting something from them where they just say, I have to bow out because, and then we move on to the next person. You know, we have that as an option. So we have some flexibility.
Sense. Okay.
I have another question. And on my living trust, I have put that I be transferred from here to Newport Beach. And I'm thinking of changing the fact that I don't want to be buried whole. I might like to be cremated. Do I need to change that in my living trust? Or can my son and I sign a document to that effect and have it notarized?
Well, you know, that's a common question that people ask. We don't put estate plans in, we don't put final disposition kind of arrangements into the trust itself, because the trust is just about inheritance specific issues. But very often in a person's advanced healthcare directive, the medical document,
Okay.
you don't have to list in that document what your specific wishes are, but very often you may have said that whoever I've left in charge of talking to my doctor for me, that person can also make my funeral arrangements and deal with those details, provided anything they know I want done, they're duty bound to do. And so the combination of that language in the healthcare directive, plus if you just write a little note and put it with the rest of your estate plan that says, you know, I'd really like to be cremated and some of my ashes will go here and some of my ashes will go there. I lost my grandmother last year. And so,
Oh, I'm sorry.
thank you. We did that very thing where, you know, it's the first time I got on an airplane in 2 years. We went back to Michigan, where I'm from. And, you know, we were out the south shores of Lake Huron. And, you know, we put an urn into the water there, a biodegradable one. It just went right in and then downstream. But then some of the rest of our ashes were taken to other places. And then some of, you know, my dad kept some and some of my aunts and uncles got some. So anything like that you feel strongly enough that you want to do, literally all you have to do is write it down and then just keep it with the other documents, because whoever is winding up your affairs, as long as they know those things are what they're supposed to do, even if they don't want to do them, the rest of the family will yell at them enough. They'll just grit their teeth and do it anyway.
Well, this happened to be a discussion over dinner the other night, so it's a good time to ask you.
Yeah.
Thank you.
In contrast, Jason, my sister had a will, of course, but she decided she was a master needlepoint artist. And she sat down with her daughter and said, I want this piece to go to Judy and this to go to John and this blah, blah, blah. And my nephew, her son, would not accept that as valid because it wasn't in the will.
Mm-hmm.
So that, I mean, that's different, but I assume that was accurate. He could block that.
Not necessarily, actually. And I'll give you an example. So all of you here today who happen to be my clients, if I did your trust, you got a special schedule just to make gifts of things like your needlecraft. And as long as you used that schedule and wrote down this item goes to this person, and then you sign and date the document. I go over it with clients when I'm doing, you know, estate plan signings, and then it's also in the instructions that I include with the estate plans that I draft. But that can be an important thing, so we don't have the family fighting over, you know, a piece of needlepoint work or a spoon, like I gave the example earlier.
Right.
You know, if mom lays it out and it says this thing goes to this person, the law is going to back that up. At least in California, it's binding. So then, you know, even if your nephew wanted to jump up and down till the cows come home, the law says, sorry, it was your mom's stuff to give away. And if this is what she said she wanted done, are you claiming that she didn't write this? Are you claiming she didn't sign this? That that's not her signature. It's the only other way. You know, if we're worried about someone coming in and adding, you know, to the list when no one was looking. But short of that, if everyone knows, yes, she really did that, then a court's going to stand behind that.
Oh, well, too bad. This is years ago, and the son and daughter have not spoken since.
Oh my goodness.
Yeah.
Well, my niece felt that her brother blocked her from acting on my sister's wishes and making sure that these pieces went to everyone. And he said, no, it's not in the will, so forget it. Really unfortunate.
Very much so.
Yeah. Anyway, I'm watching the clock, and we've taken your time, Jason, and unless anyone has anything else.
No.
Okay. Well,
Yes,
thank
but
you
one
once
quick
again.
question, Judy.
Yes.
Jason, you say you do estate planning. What does that include?
Sure. So for my clients, the estate plan is a package of several documents that all work together. The main document is a living trust, and that's to avoid probate court. It does the work that a will traditionally does.
Right.
It says, here's who's in charge, and here's how everything's going to be distributed, and here's how we handle various what ifs. And we're going to get a licensed professional fiduciary as a backup, for example. And then we also include wills. When you have a trust, you still also get a will, but that's as a backup, just in case. And it's very rare that we need it, but we include it just in case we do. We have to put assets into that trust once it's formed. So deeds for real estate, and then a blanket declaration for everything else to make it clear everything's really in the trust. And then in case of incapacity, the estate plan will also include a financial durable power of attorney and an advanced healthcare directive. So we know who's allowed to talk to the client's bank and who's allowed to talk to their doctor. And then for clients with minor children, I also include a nomination of guardians. Because, if someone has a young child, oh my goodness, who's going to take my kids in if something happens to me is a very, very important thing. So we include that as well.
I also have a dog that needs to be included.
Yeah. And, it's funny because I'm surprised. We have a Chihuahua and a Terrier Chihuahua mix. I'm surprised they haven't barked to make their presence known so far. But the law treats our beloved furry friends as property. And so that schedule I described, where we can say, here's what happens to my personal property. I tell clients all the time, if you have fur babies like I do, you can write any household pet that survives me. You don't have to identify a specific one. But then if you have someone who would be happy to take them in, that's a very easy way to take care of that.
Yeah.
Thank you. So you do mostly when people are alive and you prepare the estate for when they die. Is that right?
Yes, that's a big part of my practice. And then obviously when someone has passed away, if they have a trust and we don't have to go to probate court, like I was discussing earlier, there's still a ton of work that needs to be done. And so I also assist the people who have been left in charge of a person's affairs to make sure that they're doing the legal parts of that job properly.
Good. That's helpful. Thank you.
Okay.
Question.
Oh, okay, Goon.
Yeah, for Jason. My brother lives down in Southern California and he doesn't have a trust. Could you do one for him even if he doesn't live locally?
Ooh, that's a difficult question. I have done that before. Recently, I did that. The biggest challenge is if I'm not there for the signing, we end up having to do the signing twice. So.
No, because he could come up here. His daughter lives locally.
Oh, I've done that before as well. I've had clients from as far away as, I want to say, Orange or San Diego County to the south. And I've had clients come down from like Chico and Redding, in the north. So yeah. So I'm licensed statewide. So yes. So
statewide. Okay. So the county does not matter.
No.
Very good. Yeah. He will see you.
Well, I appreciate it. Thanks, Gunn.
Okay.
Oh, you did a good job for me. So I'm very grateful. So yeah, absolutely. Anybody wants to talk to me privately about Jason?
Uh-oh.
Okay.
He'll give us the dope.
I can tell you about him. Yes, absolutely. And he was recommended by Swedish friends that live here in town. So, and I trust, Swedish people you can trust, right?
For sure.
Okay. Well, Jason, thank you for covering the waterfront of this for us. And making us all a little more intelligent and knowledgeable. So thank you so very much.
Yes, thank you.
We'll
It's
probably.
been my
be back
pleasure.
to
Thanks
you
so much
again
for having me.
sometime.
Jason, it was
Thanks so
very
much.
Thank you,
Thank
Jason.
you.
Yeah.
Thank you.
Bye-bye.
Bye.